Thank you everyone for joining us today for this celebration of Professor Margaret Thornton's landmark work, Dissonance and Distrust. My name is Heather Roberts and I'm an Associate Professor here at ANU Law, and I'm proud and privileged to be a colleague of Margaret here at ANU. I'd like to begin by acknowledging the Ngunnawal and Ngambri peoples, the traditional owners of the land on which ANU is situated, and pay my respects to their elders past, present and emerging. Can I also extend my respect to any Aboriginal and Torres Strait Islander peoples here today? This is a very special moment for us. As news of this event started to spread, it became very clear that this book and its author have had a transformative impact on so many people. As Margaret herself has written, in the neoliberal university in the era of the flexible cyborg, it's become increasingly difficult to steal precious moments to pause and reflect on the impact of ideas. This is especially true in an industry where women are expected to compete on equal footing with their male counterparts, while still maintaining the lion's share of caring responsibilities inside the home. And this experience has been magnified in COVID times. But today we are going to pause and reflect on the impact of ideas. And I'm proud to be here today with four extraordinary academics. Emerita Professor Mary Jane Mossman, who's joining us from Toronto of Osgoode Hall Law School, Dr. Susan Bartie, Senior Lecturer of the University of Tasmania Law School, and Associate Professor Genovese from the University of Melbourne Law School, and of course, Emerita Professor Margaret Thornton herself. In my role as host today, I'll not be reading through their CVs. It would take too long for a start. As you'll know and have seen from the flyers of today's event, each are recognised as innovative and leading scholars in their field, and Mary Jane and Margaret particularly have been generous mentors and supporters of junior women in the academy for decades. At the outset, I will note that there's justified feminist critique that in some contexts, women can be referred to by their first names in order to infantilise them and minimise their intellectual contribution and authority. But please take it as read that when I use first names today to talk about my co-presenters, I do so acknowledging them as esteemed scholars, colleagues, friends and mentors, and women who I'm proud to know on a first name basis. A brief point of Zoom etiquette for today. There will be time for a Q&A at the end of the event, and I'll be keeping a close eye on the Q&A function in order to compile questions for speakers at the conclusion. So please keep them coming in the Q&A function in Zoom throughout the event. So without further ado, it's my great pleasure now to hand over to Emerita Professor Mary Jane Mossman to open the event today.
Thanks very much, Heather, and it is really a great pleasure to be here. I think it is also an honor to participate in this 25th anniversary celebration of the publication of Dissonance and Distrust by Margaret Thornton. And I'm really grateful to you, Heather, for all your help in arranging for me to be part of this auspicious event, and also for your lovely tech people who've made it possible for me to talk to you in Toronto at 6 o'clock in the evening on Wednesday, when you're at 10 o'clock on Thursday in Canberra. It's also time in Toronto when winter's almost here, so it's very good to be part of the Australian summer again. In providing these opening remarks, I want to briefly identify three aspects of this book, all of which provided touchstones for my research about women in law and for the scholarly contributions of so many others, both in Australia and around the world. In my view, it was the publication of Dissonance and Distrust that both defined the problem cogently and explored its systemic impact for the goal of gender equality in the legal professions and the judiciary, and not only in Australia. I'm going to focus first on the book's methodological innovation in relation to its feminist analysis. Second, its international significance. And finally, how Margaret and this book have provided real support for me and for many younger women academics in law. So first, Dissonance and Distrust represents a highly sophisticated methodology in two ways that are related. The book incorporates throughout the text the voices of 100 women lawyers of all ages and in many different legal contexts. The voices are both pointed and poignant, and they are truly compelling in describing and explaining the complexity of women's gender experiences in law schools, as barristers, solicitors, and judges, and in their work in community legal centers, corporate counsel offices, and the legal academy. As Margaret explained, her decision to conduct 100 interviews with women lawyers, rather than sending out questionnaires, permitted her to backlight women's experiences and then to explore this shadowy terrain, permitting insights that are seldom captured by quantitative data and questionnaires. Moreover, the voices of these 100 women lawyers were judiciously inserted within Margaret's compelling theoretical analysis of the ways in which technocentrism, the emphasis on technocratic knowledge, reinforced law's hidden norms, and how the perspectives of benchmark men have become conflated with these norms, relegating women in law to the fringes of the jurisprudential community, a really telling description in my view. This theoretical analysis complemented the women's voices to demonstrate the concrete reality of gender barriers for women lawyers. Moreover, as much of Margaret's subsequent scholarship has confirmed, her point in 1996 that technocentrism in law would only become worse has largely been proved correct. As she concluded, neither an increase in the number of women nor the passing of time can provide an automatic remedy. In my view, Margaret's feminism never resulted in an uncritical optimism about women lawyers that has sometimes characterized others' writing about women in law. And more personally, her views were confirmed for me after I spent several years doing seminars about gender equality in major law firms in Toronto. A strategy for changing the context for women in these firms that had been highly recommended by the Canadian Bar Association's Task Force on Gender Equality in 1993, chaired by retired Supreme Court of Canada Justice Bertha Wilson. Second, Dissonance and Distrust attained richly deserved international recognition and inspired other studies about women lawyers in many parts of the world. For example, in 1998, Claire McGlynn published The Woman Lawyer Making the Difference in the United Kingdom. Her book included interviews with women lawyers too, but as its title reveals, Claire hoped to motivate and inspire women in law. By contrast, in the same year, 1998, Hilary Sommerlath and Peter Sanderson published Gender, Choice and Commitment, a less optimistic study of women solicitors in England and Wales, which used feminist jurisprudence to reveal women's continued subordination in legal employment. In Canada, Joan Brockman published Gender in the Legal Profession, Fitting or Breaking the Mold in 2001, a book that included interviews with 100 young lawyers in British Columbia. Joan concluded that it is unlikely that the major revolution of equality in the legal profession will take place unless what she characterized as the bloodless revolution takes place at home. There were many other books and articles published in the United States and in other parts of the world, and many of them regularly cited dissonance and distrust. This tsunami of scholarship about women lawyers also resulted in 3 volumes published by Hart for the Onati Institute for the Sociology of Law. The first volume, about women lawyers in 2003, a second volume about women judges in 2013, and most recently, a third volume focused on women academics in 2021, for which Margaret was one of the editors. Unsurprisingly, Margaret has been in demand for years as a university visitor, a keynote speaker, and a contributor to other scholarly projects. And we've welcomed her to Osgoode Hall Law School on numerous occasions. Finally, Dissonance and Distrust, as well as the many articles and books that Margaret has continued to produce so regularly, have provided expert guidance for many women scholars, and not only legal scholars, in many countries of the world. The book's many citations to scholars in both legal and other disciplines, including Lorraine Coate and Dorothy Smith in Canada, and Julius Stone in Australia, for example, reveal Margaret's exceptional scholasticism and expertise. In this context, however, her prodigious output has never prevented her from supervising numerous graduate students, mentoring younger women scholars, and engaging in a number of interdisciplinary projects with colleagues. All these efforts have demonstrated her lifelong commitment to women and to feminism, and although she remains humble as a person, I think she is definitely a force to be reckoned with as a scholar. I'm also grateful to have been a friend of Margaret since we first met at UNSW in the early 1970s. And so I'm happy to celebrate her and her work, not only in relation to the 25th celebration of Dissonance and Distrust, but also to our 50 years of friendship. Back to you, Heather.
Thank you so much, Mary Jane, and for joining us yesterday to give us your remarks this morning. It's my pleasure to speak to the theme of women in the profession and judiciary in Dissonance and Distrust today. It's been said that Lionel Murphy slept with a copy of the Constitution by his bed. That may be urban myth, but it's true in my case that Dissonance and Distrust is either always on my desk or no more than an arm's length away. Beyond its ever-relevant observations and the wisdom of its analysis of women in the legal profession, the book is also my constant touchstone for its powerful and alliterative organising concepts that Margaret has woven so deftly into memorable titles like Dissonance and Distrust, Fictive Feminine, Benchmark Man, or Dutiful Daughter. Each are terms that you'll recognise from Dissonance and Distrust and Margaret's work more generally. And Benchmark Man is one that will be recurring this morning. As Margaret defined it, it's the term for the paradigmatic incarnation of legality and legal authority, the standard against whom all others are measured, the white, heterosexual, able-bodied, politically conservative, middle-class man of the law. But more than its specific and telling insights into Australia's legal landscape in the 1990s, Dissonance for me is the quintessential example of how great academic writing can be lyrical and joyful to read. For a reader, being challenged, confronted, and stretched can be an enjoyable experience in the hands of a great writer. In addition, Dissonance and Distrust is also a tangible reminder, as Mary Jane mentioned, that great impact can be achieved by scholars through the slow work of interview methodology and by scholars who are willing to make an investment in time and show an interest in their students, colleagues, and their community. So I'm grateful to have this chance to say now that through her work and her way of being in the world, Margaret has left an indelible mark on me, as she has on so many others. From only those brief words of introduction, I think you can see that bringing together my thoughts about Dissonance and Distrust and what it's meant to me has been both a joyful and a challenging experience. Although written 25 years ago, its lessons remain powerful and prescient. Dissonance and Distrust is truly both a time capsule for the era in which it was written, 1990s Australia, and a guide to help us understand what is happening now. And today I want to draw out some insights that Margaret's analysis and her interview data from 25 years ago provides to understanding women in the legal profession, and to reflect on its resonance with a different data set, one that forms a central part of my work, the swearing-in ceremonies of Australian judges. My project examines how those rituals of the swearing-in of judges tell a history and biography of Australia's judges, going back to 1903 across all Australian states and territory courts. The sweep of the project means that from this data we can learn a great deal about how time, space, and gender has influenced ideas about the ideal judge in Australia. And as I've studied how the ceremonies record stories of women in the law, Dissonance and Distrust has been vital to exploring and explaining the themes and trends in how judges speak and are spoken of on these occasions. It's useful to recall, of course, that when Margaret published Dissonance and Distrust in 1996, there were very few women in the Australian judiciary. It would be over a decade after Dissonance was published before the first woman would be appointed to the ACT Supreme Court or the Supreme Courts of Western Australia or Tasmania. And in jurisdictions which had their first woman judge by 1996, like the High Court or the Supreme Courts in Queensland and Victoria, those first women would often be the only woman on their benches for a considerable period. As Dissonance tells us, although formally let in to the profession decades earlier, these early Australian women judges faced significant barriers and pressures by virtue of their visible and audible differences from the benchmark man of the law. This was not least because while the law had let in women, the clubs and the old school tie networks had not. And it was these informal networks which reinforced the homosocial bonds in the profession and supported and maintained the informal patronage systems in the legal profession that was so essential to gain articles, to get into chambers, to get paid work. That is, the networks crucial for success in the profession. As Dissonance explained, these informal networks were frequently only open to members of the benchmark male community. And Margaret's interviewees explained how the women at the bar and on the bench navigated their path and how the legal community negotiated and understood their difference from this benchmark. The ceremonial archive of swearing-in speeches tells very similar stories. These first and second women judges to the bench were women who, at their own swearing-in ceremonies, sat and listened to speakers welcoming them to the bench with tales of how they were, quote, wedded to the law. That is, the stories about how their success and prowess was linked to that of their lawyer husbands, or how much they owed their success to their fathers and other men they were related to in the law, or how their brother judges and the kind barristers would assist them in their steep learning curve on the bench, given their youth and inexperience. As Margaret explained in Dissonance and Distrust, for early women practitioners, the fact that they were manned, they were accompanied by reliable men, their fathers, their husbands, their brothers. This was an important part in marking out these women as safe and capable of exercising legal authority. For other women in this pioneering judicial group, their otherness from the benchmark man was emphasised in the ceremonies in far too familiar ways, through comment on their appearance, their clothing choices, their stature and build, their voice, their friendliness, their personality, and the diets and weight management strategies that they took part in. Their feminine pursuits of needlework, knitting, sewing, and being hostess at dinner parties. And of course, their excellence as mothers, daughters, and wives. In addition, in the swearing-in archive, there were stories of how their bodies disrupted legal proceedings, stories of the pregnant barristers being carted off during proceedings while they were in labour have been read into a number of ceremonies. But while the men tasked with welcoming these women to the bench, and it was almost always men at this time, emphasised their dissonance and difference from the legal fraternity, these early women judges often, but not always, elected to minimise their difference in this era. That's understandable. These were the pioneers, the role models. By being first, they had placed upon them and assumed for themselves the weight of that responsibility. As Mary Gaudron would colourfully comment, this was the generation of women who could never afford to stuff up. They had to make sure that because of them, no one could ever say, oh, we tried appointing a woman and that didn't work. And reflecting on this era in light of this additional public burden of scrutiny and attention for the pioneer judges reinforces for me another of the very great assets of Margaret's method in Dissonance and Distrust. The anonymous long-form interview, which gives participants the space to speak without the pressure of expectation and convention that can mute public comment. The slow method of oral history interview allowed Margaret's interviewees to reflect on their experiences, uncensored by the influence of public scrutiny or the filtering that can occur through pre-formed survey questions. Rather, through Margaret's method, we hear from those women in 1996 far more and far more graphic stories of discrimination in this era. If we jump forward 2 decades, things do start to change a bit in the ceremonies. Now in swearing-in ceremonies, we're starting to hear more of the stories that Margaret's interview subjects relayed. It's in the more recent ceremonies that we learn of women judges who in their careers were denied entry to law society meetings because the venue was a man's club, of the crush of testosterone they felt at the bar, of the mother lawyer's second shift coming back into work after making dinner and putting the kids to bed, only to wave at their male colleagues in the corridor as they were leaving to work for dinners prepared by their wives who had already bathed and fed the children. And of course, of being the women judges told by presiding male judges that the court can't hear you because they were wearing pants and not a skirt. Stories like these are very similar to those documented by Margaret in Dissonance and Distrust in 1996. But it's only more recently that they're being spoken of publicly in the courtroom context in Australia. Through each anecdote, the speakers at the swearing-in ceremonies are providing a record in the court's official records about women's position as fringe dwellers in the legal profession and how this was reinforced and maintained in these early years. What's particularly interesting in the ceremonial archive at the moment is that these stories are beginning to acknowledge the discriminatory barriers and culture in the legal profession, as well as the urgent need for change. And these calls for change are now being made by men as well as women. So, for example, speakers in the ceremonies now are becoming more vocal about addressing sexual harassment and how this is a systemic issue for the profession as a whole, not something that women face or an issue for women to fix. 20 years after Dissonance and Distrust, of course, we now have a number of prominent women chief justices of superior courts, providing us with examples that judicial leadership is not only for male judges. Most recently, we've seen how our Chief Justice made a public stance on sexual harassment in the legal profession. But the fact is, 25 years should have been enough time for trickle up to work, if it was ever going to work at all. A majority of graduating students have been women for a long time now in law schools. But to play with the metaphor a little, trickle up isn't enough on its own because the hose is far too leaky. And this is precisely what Margaret foresaw and has continued to discuss in her more recent work. And here again, we're blessed to have scholars like Margaret investing the time and energy, now of course completely free as an Emerita Professor, to undertake the exacting process of empirical research. To me, it seems that we're due for a new edition of Dissonance and Distrust, not simply for Margaret's analysis of the state of play over the last 25 years, but also for her analysis of what we might expect looking forward. Margaret, of course, has been doing this through her career since Dissonance, and knowing Margaret probably already has something planned. But I, for one, would love to be able to reach across my desk and grab another beautiful book of Margaret's analysis and guidance for the next 25 years to come. So with that, I'd like to hand over now to Dr. Susan Bartie, joining us from Tasmania, for her reflections. Thanks, Susan.
Thanks very much, Heather. I'd like to begin by acknowledging that I'm speaking from Lutruwita Aboriginal land, the land of the Muwinina people. I pay my respects to past, present elders and to the many Aboriginal people who did not make elder status. I am very happy to be speaking to you today at this forum. I am very appreciative to Heather and the organisers for inviting me to speak. It is a great honour. I echo the comments of many when I say that Dissonance and Distrust was and remains a groundbreaking work of the first order. It has served as a model of scholarship for anyone wanting to think deeply and critically about the legal profession. Margaret's work is important for many reasons, but today my focus is on the way that the book has forcefully countered a sense that wrongs inflicted on women in law schools were being made right. To put it another way, it combated yet another argument or strategy used to silence women or complaints by women that they weren't being seen, heard, or respected within law schools. The book was published at a time of cautious optimism for feminist legal scholars. There was certainly a growth in works when it came to feminist legal works. The number of women legal academics was increasing, and finally the number of women law students equal to that of men. The growing participation of women in law schools made it easy for some to suggest that feminist critiques weren't really needed. Why did you need feminist critiques when women were participating in the profession to an extent, to a largely equal extent to that of men? Margaret provides a really useful rebuke. I'll quote from her work. She says that history cannot be understood in terms of an undeviating line progressing ever closer to that ideal end state, an egalitarian nirvana. The dramatic increase in the number of women law students alone cannot affect an instantaneous change in attitude without resistance from self-appointed legal knowers. Indeed, Dissonance and Distrust makes a compelling case that throughout the 20th century, women were not accepted as citizens of the law school. In the 1990s, they remained less than others. Now, 1996 was a memorable year for me. It was actually the year that I began studying law at a relatively new law school, Flinders University in South Australia. I chose to study at Flinders because it seemed at the time to be less stuffy than its more established counterpart down the hill. I wouldn't go so far as to say that the curriculum was feminised, but certainly a number of the young faculty members seemed to be teaching with a sensitivity to gender. For example, in criminal law, we heard from a woman who had suffered abuse from her domestic partner. In torts, there was no talk of the reasonable man, but rather the reasonable person. When there were texts and judgments which used a male gender pronoun, they were often replaced by a female gender pronoun. Now, this made me think that the legal world had always made this shift, or recently made this shift, but that assumption was corrected when I went to Cambridge University in 2001 and heard my law professors refer to all men, all judges as men, and also in the context of negligence refer to the reasonable man. Other features of the Flinders law curriculum included it beginning with an introductory subject where Professor Margaret Davies introduced us to critical legal thought. It also had a feminist legal theory subject, also taught by Professor Davies, where Dissonance and Distrust was a primary text. It sounds very promising and very progressive, but to me, what probably stands out most from this time is the messaging that feminist voices and perspectives and women voices and perspectives were dangerous. We were told by both our peers and members of the local profession that if you studied feminist legal theory and if you had it on your transcript, you wouldn't get a job. One of my favourite women lecturers at the law school, in her teaching or lecturing in private law, she had an accent. She was mimicked and ridiculed by a group of male students from a private law school. When she asked them to stop, they didn't, and it got to the point where during one lecture she walked out halfway through. These same male students during the criminal law lecture, where we had a woman speak about the abuse that she had suffered at the hands of her male partner, giggled throughout most of the lecture. Dissonance and Distrust helped me to contextualise this behaviour, to understand that it was part of a broader societal trend to keep women in their place and to render them less than. It helped me to make sense of kind of the anger and frustration and the sense that I didn't belong. I realised through reading Dissonance and Distrust that this wasn't about me. It was about a history and tradition which sought to keep women small. It made me feel less alone. It is this feeling which I remember most and has resurfaced when I read, well, recently, Margaret's work on universities and the academy. It is a feeling that has led me to question those who have characterised Margaret's work as overly pessimistic or have asked her to include suggestions for reform. Were it more positive, more upbeat, if it did point to easy solutions, I would have questioned my own reality. From a disciplinary perspective, the idea that legal scholarship should be normative and prescriptive has persisted. It continues to demote important critical work within the academy. Wanting problems to be resolved is, of course, a human tendency. None of us like to sit in discomfort. And yet it is only through an examination of the uncomfortable that society, a profession, or a discipline can grow. In the remainder of this presentation, I'd like to concentrate on two features of Dissonance and Distrust, which I believe has made it an important work for further thinking about law schools and the discipline of law. First, I think it's really important to acknowledge that Dissonance and Distrust is an extremely important historical record. Its importance can be acknowledged simply by imagining a world where it did not exist. In this world, we would not know or understand how women were kept out or deterred from staying within law schools, how women held a range of motivations for studying law, how those motivations influenced their experiences and perspectives, how being a woman at a law school presented distinct challenges throughout the whole of the 20th century. We would not know the names of women who received degrees in horrible circumstances only to then be told that they could not practice law. And we would not hear the voices of women who have found law schools to be alienating places. The second feature of Dissonance and Distrust, which I would like to touch on, is how it brings to the surface important questions of structure and agency within Australian law schools and universities. These are questions which have dominated my thinking for, I'd say, at least the last decade. In the context of legal education, agency is first introduced when Margaret speaks of law schools as places where knowledge is constituted by legal academics. She suggests that members of the Academy have clung on to positivist and technocratic ways of thinking and learning about law. She explains that these dominant modes of thought have provided, and I quote, a very effective technology through which the power of benchmark men can be rationalised. As my work and others has shown, legal liberalism has been a dominant strain among founders of Australia's modern discipline of law. For Margaret, this fidelity has discouraged methodological reflexivity. The intellectual and social investment in liberalism has meant that legal knowledge continues to reflect and reproduce dominant social values. This is graphically illustrated in the old criminal law classroom, where law professors who were known for calling out injustices nonetheless ridiculed the crime of rape to a series of so-called amusing anecdotes. Legal academics, as Margaret explains, have historically not only tolerated but encouraged their male students to alienate and caricature their women peers. Turning from agency to structure, Margaret points to two external forces which served to privilege masculine and technocratic values. First, she explains the role that the legal profession has played in privileging judging and lawmaking as the primary subject matter of academic knowledge. It has encouraged the discipline to remain wedded to the legal liberal tradition. Second, Margaret explains the dominant modes of governance within universities. She argues that, and again I quote, the increasing bureaucratisation of universities with their top-down managerial style favours the promotion of masculinist values. Characteristics which Margaret assigns to the fictive feminine, for example, non-rationality and emotion, has limited the potential for women to be authoritative knowers or managers within the neoliberal university. As knowledge became a commodity and top-down management styles have increased, this has maintained the power of social elites, the benchmark men. Margaret therefore suggests that structure and agency has combined to relegate women to the shadows. Her thesis suggests that even if the liberal paradigm is dented or eroded over time, the governance models which emerged in the 80s and 90s will serve to demote and marginalise women. As Margaret puts it, by rescripting and reconfiguring social relations within the academy, the sexual regime has been retained. Her work therefore suggests that feminists wanting to reform the discipline need to fight on two fronts. First, they might fight for the radical reorientation of the core of disciplinary knowledge. Until this has occurred, faith in agency, in disciplinary based knowledge, seems hollow. Second, they must contest the power structures dominating modern Australian universities so as to deprioritise masculinist values. As Heather has noted, and Mary Jane, in the subsequent decades, Margaret has gone on to conduct many more studies which build on the foundations of Dissonance and Distrust, exploring these questions of structure and agency in various facets of legal life. In a recent book chapter about feminist law professors, entitled The First and Last, Feminist Law Professors in Australia, Margaret again cautions against linear accounts of the discipline. She explains that since the 1990s, many Australian feminist scholars have risen to prominence. They've become law professors, they've become deans, and they've become heads of school. Women legal academics are now in the majority at all levels of the legal academy, apart from that of professor. Funny that. And law students, women law students, substantially outnumber that of men. At the same time, the feminist law professors who Margaret interviewed all spoke of a deep sense of dissatisfaction with the academy, and around half of them had either left or said that they were planning to leave. Margaret concludes that managerialism within the neoliberal university is in part to blame for this sense of dissatisfaction. Despite the rise of many women to leadership positions within law schools, these positions now form part of middle management. She explains that women middle managers or professors, and I quote, are expected to espouse a conventionally feminised style of leadership and defer to the masculinised uber elites, that is, the senior managers of the university. Margaret's thesis suggests that structure, perhaps more than agency, is currently what is most holding women back. It is a significant obstacle. As Sarah Ramshaw and Wes Pugh explained in an early review of Dissonance and Distrust, Margaret's brand of feminism is ambitious. It seeks, and I quote, substantive justice, social transformation, and a fundamental reworking of the capitalist underpinnings which sustain corporate lawyering in Australia. Because of this ambition, the gap between ideal and reality within Margaret's work often seems vast. Yet, as I said at the beginning, I don't agree with those who've suggested that Margaret should underplay the gap. To take responsibility for the discipline, to move the discipline forward, it is essential that we understand just how far it is falling short of its potential. And it's important to believe that the present structures of law schools and universities can be fundamentally reworked. Those optimists among us who want to bring about change cannot ignore the intellectual and structural factors which continue to oppress and marginalise women and others. Instead, we need to apply our intellectual and creative muscles to these features of the academy. To turn to another of Ramshaw and Pugh's points, the very existence of dissonance and distrust and Margaret's subsequent work provides reason for hope. If Australia's legal academy can produce a work such as Dissonance and Distrust, why not believe that members of the academy can counter at least some of the masculine tendencies and strictures? While governance structures may continue to oppress, I believe it's both possible and desirable to maintain a faith in ideas and a faith in agency, so long as it isn't a blind faith. I'll now hand it over to Anne. Thanks very much.
Thanks so much, Susan. I'm having a few internet problems this morning, so I apologise in advance if I'm fading in and out of view more than would be desirable. So I'd like to begin by also acknowledging that I speak from Indigenous country. In my case, I'm on the lands of the Wurundjeri peoples of the Kulin Nation, and I pay respects to their elders past, present and emerging. And I also want to thank Heather very much for the opportunity to speak today, and also to acknowledge the amazing help we've had from everyone at the ANU College of Law. And I really do wish that this event was taking place in person. It would be such an amazing experience to all be together and to be able to raise not a glass of champagne this early in the morning perhaps, except in Mary Jane's case, but a coffee cup to celebrate the community that Margaret has created and that we all form a part of. So when I was asked by Heather to speak today, she asked me to discuss with my views and thoughts about Dissonance and Distrust as a book of critical feminist theory. But I'd like to reorient that question slightly and consider it as a book of feminist jurisprudence, which I'll explain what I mean by that in a moment. The reason for doing so is that I want to take this anniversary occasion to celebrate and honour what Dissonance and Distrust, and in fact all of Margaret's work does and means for the development and articulation of feminist jurisprudence in Australia as a field of study, but also as a way to engage with institutional practice and thought. Like my co-panellists, and I'm sure all of you participating today, I have public and personal debts to pay to Margaret in the production of my work. Margaret was my thesis examiner in 1998 and has acted as a guide, mentor, referee, champion and supporter ever since. I'm not exaggerating when I say I owe a career as a scholar in law to Margaret, as she fostered and recognised a shared ambition to create interdisciplinary relationships drawn from feminist methods to voice rigorous jurisprudential thought. I learned from her that it is not only possible but necessary to assert oneself as a feminist from within the discipline of law, even when that comes with institutional cost, but as well as collaborative pleasures. I also learned that to assert oneself as an authorised legal knower has responsibilities, and these accrue through writing. The production and dissemination of methodologically variegated texts like Dissonance and Distrust, which train and inform readers in how to take up their own conducts of life with law, be it as students, practitioners, judges, or scholars. In my own recent writing, I've been addressing my inheritance directly as an historian of jurisprudence, reintroducing the feminist work that has shaped the present in a particular way. Dissonance and Distrust and Margaret's other books and articles are integral to this project in that they give a cumulative example of how to address law as experienced and stage an argument as to why that is a feminist provocation. Instead of writing a history of feminist legal thought in my current project, in a way that might describe, the scope of schools or isms or drill down into different doctrinal areas or research specialities, what I'm doing is taking up the training, and I've chosen to pay attention to what feminists do and show through their writing, and how that is an activity of caring for and challenging knowledge itself. Working in this way places a focus on the character and quality of the relation between the feminist scholar as an authorised knower and the care and conduct of her law as practical exercises of writing. And I've called that practice, following Margaret's own example of naming things for yourself, as jurisography. So examining the creation and maintenance of a public and scholarly persona, the feminist jurisprudent, and engaging in close reading of the library of texts that they've produced gives me a way to share, teach, and explain how to best inherit that writing, emphasising how we each might use it to name and specify the duties that fall differently to all of us based on our own situation. I've been really fortunate this semester at Melbourne Law School for the first time to have taught a research class on feminist jurisprudence, and it's this approach that I've been thinking with those students. My students are final year JD students, and I've introduced them to Margaret's work and the work of others, including Mary Jane. And the activity for us together has been to ask them to consider what these feminist books of the 80s and 90s do and signify, as well, of course, what content they carry. And it's, I think, relevant in this context to note that half the students in that class, in their 8,000-word research projects, chose Margaret's work, her provocations and approaches to facilitate their own study. They found Margaret's work, ranging from 1986 to the present, to be an inspiring and transformative experience as they wrestled with their own questions and ways of belonging to the law school. So this, of course, carries on this long tradition, as Susan and Heather have already described this morning, of what this book has meant to people and what examples it demonstrates. So informed by this very recent teaching and writing experiences, I want to offer just a few comments on dissonance and distrust as integral to what I'm calling Thornton studies, and why it is a significant contribution to the library of jurisprudential training manuals available for students and feminists at law today. My first point is about genre and audience. Margaret's work importantly crosses outside of feminist theory. I'm sure there are some here who were introduced to her through the groundbreaking text on discrimination law, The Liberal Promise from 1990, or her reorientation of law and humanities, tomes. I mention this because it is important to remind that a book by a feminist scholar is not only a feminist book. In some ways, Margaret's scholarship over her career pushes back at philosopher Michel Ledurf's caustic, but I think often all too accurate observation, that books with a title that carry the words women or feminism are often found in libraries, sectioned off under a special heading, by women, about women, for women, and half their potential readers are deprived of solid reading matter. In the example of Dissonance and Distrust, it is also, as everyone has noted this morning, a book of record of the time it was written. This is in terms of both its expert demonstration of transdisciplinary method that was merging fully into view for others in law by 1996, and Heather's already spoken at length of the important interview technique and oral historical methodology deployed, but I'd also mention Margaret's expert interleaving of the socio-legal with doctrinal and philosophical thought. And also the book shows us snapshots, as Susan has described, of agency and resistance in time and place and over time and place. Dissonance and Distrust is also, as noted by my co-panelists, a book of history in that it explains what comes before, a longer legacy of legal office holding predicated on forms of exclusion and demarcation based on sex, and how exactly women disturbed the homosocial cloisters of the law. But Dissonance and Distrust is also a book of critical theory, by which I mean Margaret Thornton, like others who were called themselves to critique as a practice from the mid-1980s onwards, challenged the very idea of a totalising experience or representation of human life, including in law. As a text of feminist legal criticism, Dissonance and Distrust focused on bringing women and into a relationship with legal practices and to exposing division and failure within law to take responsibility for diverse experience. It is this framing of a canvas for critique that Mary Jane Mossman writes about in her preface to the 1996 edition as providing a key source of the book's inspiration for others. And I'm partially quoting here in that it captures courageous voices of women lawyers and judges who talked about their experiences in the legal world, through which was conveyed a sense of purpose and persistence in the face of obstacles, enabling a sense of community rather than fraternity as people realise that they are not alone in their insistent impertinence for a change to status quo. I think that Dissonance and Distrust is and has been understood in all these ways, and for these reasons, as we've already described, is the leading inspiration and foundation for a range of significant projects. I would add, importantly, one of those being the Trailblazing Women Lawyers project that Kim Rubenstein, Nikki Henningham and others conducted in conjunction with the National Library of Australia. But for me, as it's also a key text of Australian feminist jurisprudence. If jurisprudence is understood as a body of knowledge concerned with prudence, care taken in the comportment of obligations to law, feminist jurisprudence, as my friend, the Greek-British feminist jurisprudent Maria Dracopoulou describes, becomes an ambitious and daring undertaking wherein feminist legal scholars, rather than investigating a generic engagement of what law what law does to women, instead address the law as an equal, meeting it head on, with her thinking challenging law's rationality and juxtaposing a voice and mind of her own to that of laws, to speak of law to law. For Margaret, across her work, this has meant and continues to mean a rigorous and precise interest in relations of knowledge that drew from her own intellectual and political experiences as a feminist, which informed and predated her arrival to the legal academy. Margaret Thornton's 1986 article, Feminist Jurisprudence, Illusion or Reality, was the first time the words feminist jurisprudence ever appeared in an Australian law journal. And Margaret's argument, one that she has honed ever since, is that feminists had to go into relationship with legal knowledge, which of course informs the fields of legal endeavour, with their eyes open. As Margaret has noted to me in an interview we conducted in 2015 about this essay, she says, there was this whole question mark as to whether there could be such a thing as feminist jurisprudence in fact, or whether because of the way jurisprudence has been constructed for centuries, that it was actually impossible, that the feminine was always going to be cast aside. Really, it would be a poor thing to take on the language of jurisprudence without it actually meaning anything very much. So this brings me to my second point, which is about language and intention. And I emphasise that quote of Margaret's because all of Margaret's work that followed, including in Dissonance and Distrust, sought to develop language and content to both disturb that lineage, but also give the disturbance substance and meaning that was capacious enough to refract the key move of 20th century feminist intellectual authorisation. That is, it is insufficient to propose a feminism that replicates the binaries and hierarchies of phallocentric thought and its translation into professional life. If it is important to conduct the ways that male law disqualified other knowledges based on women's experiences, it was essential that the category woman was not reduced to singularity in the process. The point of noting and documenting the diversity of lives lived with law in Dissonance and Distrust is not just to reify woman to man, but to pluralise and complicate, maintain ambivalence in the face of acceptance and vigilance in caring for law's conducts towards those different from yourself. As a shorthand for what these various projects entailed, Margaret, of course, developed a language of her own that has endured. As has already been described by Heather and Susan, the fictive feminine, but also enduringly the naming and exposing of the benchmark male, he of the Clapham omnibus, the reasonable man, the cipher for lived experience that mirrored the actual experiences of law professors, judges, barristers and solicitors, as Anglophone men, white, Protestant, heterosexual, who denied themselves an existence outside a public realm. My point is, however, that when staging a conversation through these thought figures about letting women into the legal profession and measuring their success, Margaret makes an argument about challenging the very underpinning of what success means. In Dissonance and Distrust, the interrogation of women's relationship to intellectual order becomes visible because of the examination of daily life, not simply the other way around. As she notes, and I'm quoting, this is from the very start of the book, the issues transcend the mere letting in of women on equal terms with men. It invites a provocative line of questioning, such as whether it is possible for women to speak through law in a different voice, whether it will be possible to recreate themselves as legal subject, and whether women in law can transcend the oppressive misogynism with which the entire Western intellectual tradition is saturated. There are many questions for one book, she notes, but they cannot be addressed without first considering the antecedent issues pertaining to the conditions under which women have been let in. I think the key thing that I've learned from this book is that women's inherent distrust and dissonance disturbs orthodox jurisprudence, but also by her very act of writing about it, Margaret creates a space for that jurisprudence to be remade. Margaret, of course, as noted, has not stopped challenging, questioning, disturbing and writing. 1996 is a marker of her mature intellectual contribution and a prelude to the indefatigable commitment she has shown ever since to maintain those spaces from which we can all accept the challenge to question and remake the worlds of law we inhabit. So Margaret, as if we were in person, as noted, a toast to you and to Dissonance and Distrust and to the work to come. As a community, we want to acknowledge that how we do our work and where we do it has been made possible by your leadership and intellectual courage. So thank you.
Thank you, Anne. And that's such a beautiful way that we can now move in to invite Margaret to give a few thoughts in response. I'd like to add, though, that, and I really think I'm going to have to steal your thought there and definitely propose a subject called Thornton Studies for the ANU College of Law. I think it would be a huge asset to the program. So, Margaret, we've heard so many different ways of describing your work and Dissonance and Distrust in particular, courageous, questioning, indefatigable. These are only a few of the terms that have been frequently raised now. So it's our pleasure to invite you now to give us your thoughts on Dissonance and Distrust's 25th anniversary.
Thank you very much, Heather. Well, I'm just really overcome and so honoured by the comments that have been made. And so I thank you, Heather, for organising this tribute to this book, which I had no idea would have a life after 1996. I thank Mary Jane, who was one of my first teachers in law school, and I honour her. And I thank my friends then, both Susan and Anne, and for their really impressive and overwhelming contributions. I really had tears in my eyes. And so it's difficult for me to comment now, but I'll make a few comments. So one of the issues that people would raise is, what has changed since 1996? And of course, there is this notion that I think within liberalism that things are always getting better, that we're somehow on this trajectory towards an ideal end state. And so certainly in terms of numbers, which is often what people look at first, although I do remember one professor at Yale saying to me, well, you've got the vote, what more do you want? So, that's a classic as well. But the other is in terms of numbers. And we already had 50% women students in 1996. So that number has increased. And so we've seen, there's more than 50% lawyers, for example, and the number of judges has certainly increased. At the time I did that research, I remember I had enormous difficulty sort of gathering some of this data together. And, if you're writing a book, you have to have the data. And I had to write individually to every law society and law school in the country, trying to actually obtain some basic data, because it just wasn't available. It seemed to be a bit like the 19th century, that gender wasn't a legitimate category of analysis. So that was very difficult. So that has all changed. And so one of the questions then is posed is, has anything changed other than the numbers? So, that is a difficult question to respond to. So Bertha Wilson, the Canadian judge, said about 30 years ago, well, what difference would it make for women to become lawyers? Will they actually change the nature of judging? And so that I think that is still an issue that continues. And so it's often forgotten, I think, that institutions change individuals. Individuals don't necessarily change individuals. It's often thought if someone who is progressive and perhaps even radical moves into an institution, that the nature of that institution will change. But that isn't actually the case, because there's often, and particularly for the trailblazers, a desire to fit in, and so that they will tend to follow then the orthodox line of thinking. And so with the judging, for example, a denial of subjectivity. And so, the seemingly, feminist lawyer will actually then submerge that aspect of herself to try and fit in and to be accepted. So it is, an ongoing issue, and you find that with any other position, particularly in terms of positions of authority. But of course, we do see the changes in terms of the, in academia. I think particularly the nature of writing, the interesting and challenging research that is developed. In teaching, maybe there hasn't been that much of a change. So in 1996, was actually the year that I was involved in chairing a committee on preparing materials on to try and to encourage young male students to be sensitive to issues of gender. And so that these materials were produced for the Priestley 11, the 11 compulsory courses and sent around to all law schools. And we actually had some money from the Keating government to do that. But what difference did it make? You know, when I speak to people today, they've never heard of these materials. So I think they just disappeared. And there was resistance from some of the male teachers who thought, well, you know, this is going to interfere with my autonomy and independence. I don't want to be told what to do. And so they seem to have largely disappeared. So that was sad. So some things have sort of moved backwards. And also 1996 was the year that John Howard became Prime Minister in Australia. And there was quite a conservative turn then. And really, we saw then the removal of, a lot of progressive measures that had been developed at the federal level and so on. So I think, I think we have to think about this, what is the nature of politics at the time and how that actually affects the move towards a more progressive feminist understanding, that these things don't operate in a vacuum. And certainly with quite a bit of my work, I've been interested in the way neoliberalism sort of impacted, well, particularly on the academy, but also we've seen the neoliberalisation of the legal profession. And so the amalgamation of firms in Australia with those in London and elsewhere, so that you have these huge mega firms. And so once the firm becomes bigger, there is less concern with the individual players, and that we find that those significant managerial positions are occupied by men. So, there's a sort of, masculinist dimension to that as well. So things are not progressing evenly towards a better state when we think about those things. But other things have been positive. I think the hashtag Me Too movement, sexual harassment, has been very interesting. And so that when I did interviews with women, I remember one woman who was sexually harassed in her law firm felt that she had to actually leave the state. She couldn't complain. It was so horrendous. But now we've had significant changes, and so with the Dyson Hayden case, for example, the former High Court judge, associates coming out and speaking about him, and so I think that's been significant, and of course it's been picked up by the respected work study, and there are ongoing changes there. So I think that has given then the courage to young women to speak out and not to tolerate the sexual harassment that they've, that was often really par for the course in the past. But nevertheless, I think that we do see micro inequities continuing. So beneath the surface, the put downs that women have to put up with, the implicit bias, sometimes called, or which encourages the homosociality, appointing of mates. And so I think private boys' schools, the sort of club life continues. And I mean, club life, not just metaphorically, but in fact, of course, this year, the Australia Club, one of the most prestigious club, or probably the most prestigious club in Australia, then affirmed its decision not to admit women. So, and of course, who belongs to this club? The judges, senior judges, partners, and so on. So, I think we still see then bubbling beneath the surface this antipathy towards women. So one of the other things that I'm particularly interested in at the moment is in terms of who cares. And so we still, there's the expectation that women are the ones who then will will care for children, aged parents, the sick, and so on. And I would like to see, more men engage in caring. And I've written about this, but it's very difficult to change. And there's really very significant discrimination against women in the workplace once they become pregnant. That still continues. That they're made redundant, or things are so difficult they can't continue. So that's one of the practical things that I'm interested in changing at the moment. But otherwise, I think that women, young women, are empowered to speak out. I think sexual harassment has been important there, and that we want to encourage that. So the voices of women, and particularly women from diverse backgrounds, we didn't see very much of them in the past. I think that that's become very important as well. And so that notion of cultural diversity to be realised within the profession, that it's not just the home of benchmark men. Anyway, I think we should have some questions. So I'd like to thank everyone very much, and I'm enormously honoured by this event. Thank you.
Well, thank you very much, Margaret. And we do indeed have a string of questions from the Q&A. I'll take the liberty of reading a few of those out for the panel members. One question that's come through, and is actually a theme in a number of questions, is the extent to which, despite the fact that we've been able to discuss here the exceptional value of interview-based research, like that exemplified in Dissonance and Distrust, the Academy has remained relatively reluctant to adopt interview techniques more broadly. And so the question is really, what does the panel want to say about that? And is there scope for more interview methodology, and how might we explain its relative absence? I'm happy to throw that generally, but also I note that it's getting later and later for Mary Jane. So if she would like to perhaps reflect on any Canadian experience there. But over to the panel.
Well, could I comment on that? Because I think there is a favouring of anything to do with numbers, and so that if you have data that has large numbers, that seem to be somehow more persuasive than the subjectivity of interviewees, is my view. But Mary Jane.
I can say that I'm currently involved in a project that I've been working on for a long time, off and on, off and on, off and on. Do you have projects like that, or am I the only one? But it is a project that tries to identify and explore the experiences of women who became lawyers in Ontario between 1892 and 1957, so a period of about 6 decades. I found 187 women in those cohorts, but that meant that there was probably not more than half a dozen in any one year. So they were obviously very small in number. But I had the great fortune to be able to look to an organization that is a Canadian legal history organization that is based in Toronto. And back in the late 1970s, 80s, and 90s, they decided that they would start conducting interviews with members of the legal profession. Now, it will come as no surprise that the vast majority of the interviews were conducted with male lawyers and male judges. But at some point, someone said, oh, there's these old ladies around and they practiced law too. And so having access to their voices has kept reminding me of how impressed I was to listen to the voices in Dissonance and Distrust. So I can say that there are often places where I wish that the person who was doing the interview had pressed the person who was responding a bit more. And there's no question in my mind that conducting the interviews is in fact a serious and professional kind of activity, to know enough that you're asking the right questions, to know when to listen, to know when to pursue something. But I think that it is interesting to me that more and more people are becoming interested in these interviews, and there are now something in the order of, I think, 400 or 500 of them that used to have to go to our Ontario archives to look at them, but they're now digitized and you can get them online, which is really also quite amazing. I do think, though, I have had a couple of situations where I've had graduate students who wanted to conduct interviews, and my sense was that they thought if they just showed up and asked questions that they would learn a whole lot. And it seems to me that there is really something that is critically important about the quality of the interviewer in order to get the interviewee to express things that are important to them in a way that one can actually understand, appreciate, and etc. So I do think I'm quite lucky that in the context of my situation, I've had access to interviews. I've pored over newspaper reports, but as I think it was Heather who said, newspaper reports about women lawyers in these 6 decades I'm looking at usually talk about how they look and what they're wearing. They don't really do very much more than that. So the interviews are really very significant. Other people might have other views.
Yeah, I was just going to add to that I'm looking at the first question in the comments, could be read a couple of ways. That one is, why has the Academy remained reluctant to adopt the insights of Margaret's interviews is the other way to read that. But I think looking at the techniques of oral historians and the merging of relationships between history and socio-legal scholarship in particular, in which Margaret has sort of pioneered and demonstrated since that time, I think is powerfully developed in many pockets of the Australian Legal Academy. And I think I did mention the work that Kim and others have done on trailblazing women lawyers, which was really exemplified that as a set of techniques. But, it is, I would absolutely agree with Mary Jane, there's an art form, and actually understanding the difference between what a whole of life narrative, or what the relationship between the interviewer and their situated experience, so that the interview subject feels, in a safe space to speak. And I think the anonymity is the key element of Margaret's methodology, which I really think is would really emphasise to produce those kind of results. But it is quite distinctive to what we might think of quality socio-legal interviewing. And I think that's just a few comments on that question. But maybe, Margaret, you want to also think about why the Academy has remained reluctant to adopt your recommendations that came through your...
I'd also like to add in relation to that question a couple of points. I agree with Anne completely about the power of the anonymity of the interview process. I've often wondered whether or not the fact that interview methodology is inherently a slow, non-desk-based type of work. It takes that time, that patience. It also includes in it ideas about questions mediating the public and the private, whether some of these things are very much seen as women's work in terms of taking long conversations and caring conversations and stopping and listening and not necessarily voicing your own opinion, but rather waiting to hear for others, whether these are seen somehow as women's work and marginalised in that sense in the academy. And certainly if you have a look at all of the wonderful interviews that are deposited at the National Library of Australia, many of the oral historians there are certainly a tribe of exceptionally good women, but whose intellectual contribution to the art and craft of oral history, as Mary Jane has indicated, is often uncredited, because of course the work done in oral history is thought to be of the interview subject, without recognising that the skill of knowing when to stop and pause or probe and ask that extra question is a huge intellectual contribution to the data that emerges after that. But Susan, I don't want to cut you off if you would also like to comment on this excellent question.
Thanks, Heather. Just a few thoughts. I guess I agree with the comment that certainly interview-based research seems to have increased, but I guess it depends on where you look. So it depends on what field you're in. And I was thinking it would be fantastic to conduct a study to, try and find out. And I guess a question that's come to my mind is, the extent to which socio-legal, law and context kind of scholarship has played a part in Australia's legal academy. I think that would be a really interesting project that is yet to do. We haven't really studied our ideas and our methods and taken our discipline, I believe, as seriously as we ought to have done. Of course, there is the question of complexity. The kind of pockets that I'm in and looking at the moment, I'm looking at environmental law scholarship, and there's been a huge debate over the last decade where environmental law scholars are saying, our discipline lacks maturity. We've got to get better in terms of our methods and our theories and so on and so forth. So, and kind of an invitation to have a more critical conversation. I think that would be, certainly worthwhile and something that's lacking in a lot of fields of law. So we should be having both those critical questions. And I guess to return to Margaret's book, not only advocating for more empirical studies, whether they're qualitative or quantitative or a combination of the two, which I think can be quite powerful, but also thinking about the theory and the reason why you're doing this work. So Mary Jane was talking about, the technique. To me, our PhD students kind of go along and get certain textbooks from the social sciences that talk about interviewing. To me, equally as valuable is looking at books such as Margaret's, where this work has been done, and trying to unstitch them to really understand not just the theory of what makes a good interview-based project, but how this has been done successfully. So I think that's hugely important for people wanting to move into these fields.
Thanks, Anne. We've had a question also come up on from Kieran Pender, who's asking particularly to Margaret, wondering if you could reflect on the intersection between two key aspects of your scholarship, women in the law and anti-discrimination law. And he asks, beyond the obvious application of the latter to the legal profession, have you found studying the two fields simultaneously has helped you develop your methodologies and your insights in relation to each?
Well, yes, certainly that was the case, because I did work, first of all, on anti-discrimination law generally, and then sort of moved to look at the legal profession and the legal academy that I was interested in, and so applied values and insights from anti-discrimination law, because it seemed to be that the legal profession was, in fact, a very good case study of discrimination law in practice in Australia. And that certainly proved to be the case, although I suppose that the legal profession then took on a life of its own, and the understandings of anti-discrimination law sort of moved to the periphery, but they were certainly very important.
Thank you. Now, a very practical question, but I think one that really does need to be addressed. We have an anonymous attendee asking a question. Where do we buy Margaret's book? And I think the concern is, I saw a tweet in relation to this event, that someone had said that they had found one online, but it was $500 because it was out of print. Margaret, is that true? Do we have to go and borrow the earmarked library copies now if we're not fortunate enough to actually own our own?
I certainly can't verify the $500. That's very surprising. But Oxford University Press had published, 3 of my books, and then they moved, I think in the late 90s, to publishing in Australia legal textbooks because they thought there would be more money in that activity, and they gave up on scholarly books because they felt no one really wanted to buy them. They might want to read a few, but they didn't really want them at all. So yes, it is out of print, and so I'm sorry about that, but it's dubious that I think to rely on Oxford University Press to come back to that, because they would feel, for a book like this, that there was no longer a market. And so, it's really the question of maximising profits that's important to publishers these days.
Well, I think that's another reason why we either need a supplement or we need to consider a new edition. Strong urging to Margaret on that one. Look, we are very close to the end of our webinar now, but I wanted to pick up on a question or a comment that Margaret made in relation to her new work on who cares and the need for men in the legal profession to be able to take up the challenge of greater caring work. And I wanted to throw it to the panel generally and Margaret in particular. Is changing the stigma about caring is one site that we need to think about doing that now, really changing the stigma around men taking breaks in their careers for parental leave. Just looking at my data set of swearing in ceremonies, there has never yet been in the speeches I've seen commentary on any man appointed to the judiciary who's ever taken a career break for caring leave. We've seen the extraordinary work that Margaret has been able to do with interview methodologies of women, but do we need to press further on the question of men and parental leave to move this forward? Margaret, a long-winded question. Did you want to start in relation to that with your work on who cares?
Well, it's certainly true that there is a stigma. And so I have done some interviews with men and women more recently in the legal profession. And so that if men worked flexibly, they could actually be punished. They may not be promoted. This is in terms of law firms. They may not be promoted and they might actually have to leave. They would certainly have to leave one of the bigger firms and go to a smaller firm or set up on their own. Although just recently, in the last couple of months, several of the big international firms have announced that they now have a policy in terms of promoting flexible leave and paying those who are engaged in caring for children, whether they're men or women. So whether that'll be taken up, I don't know. I think it'll take some time to overcome the stigma. But, there is a consciousness of this, and I think working at home as a result of COVID has probably helped to really allay some of that stigma.
Well, it would be a wonderful thing indeed if COVID could have a positive outcome in a particular area. I now sadly need to play the role of host in bringing this webinar to a close. Can I thank enthusiastically all of the participants, all of the people listening in the cyberspace for their enthusiasm as well. Mary Jane, thank you for joining us yesterday. Anne, Susan, Margaret, thank you for participating today. And it goes without saying, Margaret, that none of us would be here without you. We're very grateful for your wonderful work in Dissonance and Distrust, and also for everything you continue to do for women in the law and for all of your colleagues as inspiration and mentor. So thank you everybody for joining us, and I look forward to the next 25 years being inspired again by Margaret's amazing scholarship. So thank you very much.